Welcome to Democracy Explained, a podcast by Apathy is Boring. In this series, we explore the pillars that hold up our democracy: participation, information, pluralism, rights, and elections. I'm Sam Roosh, Executive Director at Apathy is Boring, and your host of Democracy Explained.
And I'm Lee, also a co-host here on Democracy Explained. In today's episode, we ask, do you know your rights?
I think we take a lot of rights for granted that we think we have, but in fact, in the Canadian context, having a constitutionally set guarantee of rights like the right to freedom of expression, the right to association, peaceful assembly, legal rights, the right to be presumed innocent, equality rights, all of those rights did not exist in our Constitution before 1982. My name is Pearl Eliadis. I'm a human rights lawyer. I'm based here in Quebec. I also teach at the Max Bell School of Public Policy, where I'm an assistant professor professional, and I've been teaching for 12, 13 years at the Faculty of Law at McGill University. So it really took more than 100 years, more than a century, for Canada to evolve from being a dominion state that was subjugated to the United Kingdom to really having its own Supreme Court that was the court of last resort. And also this idea that Pierre Elliott Trudeau came up with in the 1970s, early 80s, to entrench a Charter of Rights and Freedoms that contains all the rights and freedoms that we grew up with. So voting rights, the right to move around the country, right to bail, the right to be presumed innocent, the right to be free from unreasonable search and seizure, and of course the right to equality, which came in a few years later in 1985.
Just to pause for a sec. The Charter is part of Canada's Constitution. It protects everyone's rights and freedoms and basically limits what governments can do so those rights aren't violated.
The Canadian Charter of Rights and Freedoms means that a government cannot pass a law, except in this notwithstanding clause situation, that overrides our fundamental rights and freedoms. And it changed the legal landscape, and not just the law over there as something hiding in the corner that nobody understands. It affects your everyday lives, your interactions with the police, the way that the government interacts with you, the rights that you have as a citizen, the rights you have as a resident, a newcomer to Canada. All of those things are uniquely and specially protected in a particular way by the Canadian Charter of Rights and Freedoms. All three parts of government are legally bound to respect, protect, and fulfill the Canadian Charter of Rights and Freedoms. All three. But of course, they don't always get it right. But more often than not, the way that these rights conflicts come up and bubble up into society is when the government passes a law, the legislature passes a law, or the executive implements a policy that violates the Canadian Charter of Rights and Freedoms, at which point the Canadian Charter of Rights and Freedoms kicks in and gives anybody the right, anyone who's affected and has what we call standing, has the ability to go before the courts, the right to go to the courts and seek what we call a remedy. And that remedy could be damages. That remedy could be declaring the law to be inoperable. That remedy could be striking the law down and giving the government time to go back to the drawing board. It could be a particular order to do or to not do something. By its definition, the Constitution of a country is the super law that applies to everybody, but it only applies to government action. So if you discriminate against me, for example, in renting an apartment, I can't use the Charter. I can't use the Canadian Charter because neither of us is in the government. This isn't a law. This is just you behaving badly or me behaving badly, depending on the situation. So it has to be government action, and any citizen, and in some cases anyone, really important. Think about what's happened in the United States with everybody and their uncle being deported. In Canada, the right to life, liberty, and security of the person attaches to everyone, not every citizen, not every person with citizenship and PR status, everyone. And this is fundamental to who we are as a country, in my view.
So maybe we can talk a little bit about Section 1, because I always find this to be really sort of an interesting tension and dynamic. So all of these rights are exist and are available, but they're sort of limited, from what I understand, by this concept of like the public interest or public well-being. Can you talk a little bit about like what that looks like in this context? I guess the courts kind of decide, how does it work?
Section 1 is all about recognizing that all rights are created equal, and at the same time recognizing that sometimes something's got to give. And how do you decide what's going to give, even if it's a fundamental constitutional right? You do it by looking at Section 1, so that even if you have a law that has been declared unconstitutional, let's say hate speech laws. Hate speech legislation inherently violates the right to freedom of expression. There's no debate about that in Canada. But the courts have said, yes, it violates the right to freedom of expression, but it is such a dangerous tool, one that promotes the vilification and detestation of peoples based on their personal characteristics, painting them as barbarians, as the kinds of people who are going to cause the decline of society, the people who are stealing other people's children and doing terrible things to them. This kind of language dehumanizes and objectifies entire groups of people and primes the pump really for what comes next. And what comes next, of course, is ethnic cleansing, genocide, and atrocity crimes. And we've seen this over and over again in history, right? So what you're doing when you authorize hate speech is that you use a strict set of tests that come out of Section 1, which helps you decide whether or not the law, notwithstanding the fact that it's violated, or despite the fact that it's violated the Charter, whether it can be demonstrably, that means you need evidence, justified, the evidence shows that you need to uphold this limitation on rights. So that test allows the government to, within reason, based on evidence, the Oakes test essentially requires the government to demonstrate that there's a pressing and substantial objective at hand, that the government is trying to do something that is pressing and substantial. So coming back to the hate speech example, there's a pressing, substantial, really important objective in place to protect people against the harms of hate speech. So these are the kinds of things that the courts consider. Now, of course, when legislatures are planning their laws, they also have to do charter proofing. They also go through a process where they check to make sure the legislation is compliant with the charter. So they go through their own process. And then when the legislation is passed, if there are people in Canada who believe, or other governments, other levels of government that believe that the law is not compliant with the Canadian Charter of Rights and Freedoms, they can bring particular types of actions, seek declaratory relief, seek a reference to the Supreme Court of Canada. That can be done as well. Asking the court, does this comply? Have we got this right? So that dialogue, right, between and among society, the courts, and the legislature is part of our everyday world, whether we're aware of it or not. So there are lots of holes and gaps and areas that need to be fixed, and I'm not diminishing the significance of those. But our system, on the whole, I think is working well, and it's thanks in part to a judicial system that is an unelected, professional, qualified, trained, and experienced group of people who adjudicate cases in a nonpartisan way. I would go so far as to say it is one of their most important characteristics that they're unelected.
I think the next logical thing for us to talk about in this context is probably the famous notwithstanding clause. And I know that being based in Quebec, of course, like this has been a long-standing issue, but can you explain a little bit to us how that happened? But also, what does it mean? What are the norms around it? What's changing in terms of how it's used? Like, tell us about it, because I think a lot of people hear about it, but maybe don't necessarily understand like why it exists in the first place and what it means.
Once we became a state party and were legally obliged to respect, protect, and fulfill the rights in them, we then needed to bring those rights from floating around in the international clouds and grab them and bring them down to Canada, to the ground. And that requires law. And so Pierre Elliott Trudeau, who was Justice Minister and then Prime Minister of Canada, said, right, we are going to have a constitutional process that's going to require the agreement of the provinces to entrench these rights. And the only way that he could get the deal was by putting in this escape clause. So the idea was, okay, we had to get this deal. If we didn't have Section 33, we probably would not have had the deal. Provinces would not have agreed. They didn't want to give up their sovereignty. And there was this escape clause. There was this Control-Alt-Delete that was available.
All right, so for our listeners, Section 33 of the Charter, known as the Notwithstanding Clause, allows governments to temporarily ignore certain charter rights when making laws, but they have to renew that power every 5 years.
But this idea that rights are rights are rights is not true, never has been. In Canada, you're starting to see more populist governments who are taking their cues from a reform conservative agenda, a populist agenda, who are these courts anyway agenda, they're unelected, that sort of language.
Pearl, can you define for us in this context populism? Like, how are you?
Yeah, it's a great question. So I use populism and demagoguery and, to a lesser extent, fascism in the following way. First, it's a government that uses othering as its strategy to create divisions among people. These people deserve rights, these people don't. So that is an appeal to the majority population, right? Using wedge politics in order to get your votes by vilifying or othering particular groups in order to preserve what they would call their ethno-nationalist identity. And that's what I would call populism. Fascism takes it to the next step and uses those strategies, ignoring the rule of law and putting in its own institutions, its own very partisan executory administrative institutions that are just worried about making sure that the political will is in place and actively going after those who do not agree with it.
Have you got any recent examples where this happened, and what were the results?
Very recently, the Saskatchewan government passed legislation that you may have heard of in the news, saying that for children under 16 years of age, that if they wanted to change their pronouns, that their parents or guardians had to be advised. And so 2S LGBTQ plus groups took this to court, saying this violates the children's rights because they're actively being treated differently, or I shouldn't say they're being treated differently because chances are only a gender fluid child would do that, but they are being denied their right to substantive equality, meaning there's certain things you need to do to make them feel at home, to make them feel comfortable, to make them feel safe. But the government, as you may see where I'm going, invoked the Section 33, it invoked the Notwithstanding Clause. Okay, and I thought, going up to the Court of Appeal in Saskatchewan, that the Court of Appeal was going to say what the Supreme Court of Canada had set up until now, which was, there's nothing we can do. Our hands are tied as courts. Once the Section 33 has been invoked, poof, the rights disappear. What the Court of Appeal in Saskatchewan said was, of course, as a lower court, lower than the Supreme Court, we are bound by precedent to follow the Supreme Court's earlier rulings. But the Supreme Court did not decide in those previous cases that the actions of the government were immune from something called judicial review. It doesn't mean, said the court, that we can't look at it. It doesn't mean we can't make comments about it. It doesn't mean... So that's a new door that has opened.
What is a judicial review exactly?
Judicial review is an ancient common law going back centuries process where the court can bring a structured inquiry to the legitimacy of government action. There are many, many other aspects of criticizing government action that are not necessarily grounded in the Charter. All of these cases have forced us to be very creative with looking at pre-constitutional documents. Do they give rights, interpretive provisions in the Charter that are not touched by the Notwithstanding Clause? So, the interpretive value of multiculturalism, of the equality rights of men and women, can those be bootstrapped into the way in which we interpret laws if we don't have access to the Charter? If you're supposed to be interpreting legislation in a way that's consistent with multiculturalism, under the Canadian Charter of Rights and Freedoms, but you no longer have access to the right to equality in Section 15 because it's been notwithstanded. What does it mean now? Some of the legislation in Quebec has been very problematic. The latest report just filed yesterday by the Quebec government taking sort of Bill 21 even further and taking it into daycares and restricting the rights of universities to provide support to religious groups on campus, and unilaterally amending the Canadian Constitution 1867. I mean, this is a fundamental sea change that the Quebec government is proposing. And how bad does it need to get before the Supreme Court of Canada can say or will say that the unwritten constitutional principle of the protection of minorities actually means something? Right? How bad does it need to get? Do we have people being chased down the streets? That we have governments going into offices because Section 8 is included, right to be free from unreasonable search and seizure? I think for most people, they're kind of confused. They don't realize what might be happening. But we, particularly in Quebec, but some of these populist reformist kind of measures in other provinces, I think are actively endangering minority rights and using a notwithstanding clause to achieve those goals, I think is a national disgrace. And I think the people of Canada need to be holding our governments to account at the polls every time a government uses the notwithstanding clause. And young people need to go and vote.
In terms of charter rights, I think one of the things that we think about is that, in order to have a thriving democracy where everyone is able to participate in our collective governance, we need to have basic rights and fundamental freedoms available to every Canadian. When you do your work, what role do you think that plays in the way that you see rights? Do you think about it sort of how do you connect it back to democracy, I guess?
You can't have a democratic structure that doesn't care about the people in it. And having people-centered, people-first public policy is grounded in the idea that people matter, that their individual rights matter, that their collective rights matter, that their ability to live the lives the way that they see fit, free of government interference, matters. And that's what human rights is all about. It's about protecting that freedom and that equality, and the two are bound together. You do not have a democratic state without human rights. It doesn't exist anywhere. People lead that change, and that their participation in the process necessarily means that their rights as humans, that their essential humanity is valued, and that's at the core of what human rights means. You cannot have democracy without human rights.
Amashgate and Sheshketya, the Latul Kan, Statliam Kan, Shamakwam Kan. Hi everyone. My name is, traditional name is Katya, which translates loosely to the loving dad, which is what I aspire to be with my two daughters, Riel and Macy. I'm from the Wet Nation, Shamakwam Nation, and all part of the Statliam Nation. And I currently reside in Snuneymuxw territory, out in Nanaimo, BC, where my wife and my children are from. In addition to being the executive director at the Center for First Nations Governance, I'm also the National Community Research Director for the Rebuilding First Nations Governance Project, which is in partnership with the Center for First Nations Governance and Carleton University. Essentially, what we're trying to do in both, CFNG and RFNG is really educate our First Nations community partners about the impacts of the Indian Act and their inherent right to self-government. And we're hoping in doing so that we're going to be able to convince or empower our community partners to make that declaration on we want to move outside of the Indian Act into exercising our inherent right to self-government.
Okay, quick explainer. The Indian Act is a federal law that regulates many parts of life for First Nations people in Canada. It's been widely criticized for being colonial and limiting Indigenous self-determination.
I think back to my friend Dr. Francis Abel, who says, the Indian Act is essentially First Nations communities' constitutions, because it talks about who they are, what they can do, and how they can do it. It displaced our people. It changed the way things are done. And we're really trying to educate our community partners on this is what the Indian Act has done for the last 200 to 300 years. Do we still want to do this? You know, I think about my friend Dr. Satsan Herb George, who's the president of CFNG, and he says, under the Indian Act, you're wards of the crown. And he also shares that the children that are being born today are the seventh generation of children being born under the Indian Act. And we've spent the last almost century fighting and asserting our inherent right to self-government. Because our Constitution, the Canadian Constitution, is a really interesting document. The Charter is part 1 of the Canadian Constitution, and part 2 of the Canadian Constitution is the one that we focus on at CFNG. And that is called Section 35, and that looks at Aboriginal and treaty rights. So what we had to do as First Nations people is we had to utilize the court system to really get those rights recognized and included under Section 35. And what we really advocate for, too, with the inherent right to self-government is the inherent right to self-government was not created by Section 35 of the Canadian Constitution. It wasn't created by federal or provincial government. The inherent right to self-government comes from within. We've had the inherent right to self-government recognized for a long time, but we're not doing too much about it. My boss sat and says, well, what's going on here? We have this. Why aren't we doing anything? And then he found out people aren't aware that that right exists. So that's when he created these workshops on the inherent right to self-government. So at those workshops, we educate them on 1, the Indian Act, the history of it, the impact of it. 2, the inherent right to self-government. 3, how did we get here? How did we get that inherent right to self-government? And 4, the strategy on implementing inherent right to self-government. So even though we're viewed as experts on the inherent right to self-government, we're not an expert in your inherent right to self-government because each community self-governed differently. And they're the experts. It's the knowledge keepers, it's the elders, and it gets them to think differently. One of the terminologies I like to think of is we're reawakening it. So as a result of reawakening this and empowering our community, it brings a lot of hope from our community.
Can you give our listeners some examples or ideas as to how rights would be implemented under Section 35?
More so on a concrete implementation, there are a few opportunities in Canada where you can actually start to do some implementation. We have Bill C-92, an act relating to the protection of children and family services. And it is one of 2 pieces of legislation in Canada that exist that recognize the inherent right to self-government, which is huge. And as a result of this, they have these things called an Indigenous governing body. And this Indigenous governing body can be a governing body that the Indigenous community wants to create. So it can serve as an opportunity of bringing back your traditional governing structures. But has that been the case? Not really. But let's say if something did happen, that would be the perfect opportunity to look at implementing your inherent right to self-government. You'd be creating your own laws, your own governing body. You'd likely need your own constitution, and you'd finally have that jurisdiction back under Section 35 of the Canadian Constitution. So that is where things get really exciting, but it's not happening.
Why do you think that is?
I've been thinking about it. I've been talking to my friends who are in higher level positions in these communities. So why don't you think it's happening? And their response is, well, maybe 1, they're not aware of it, this opportunity, and 2, is a sense of urgency to look at creating a constitution, to look at creating your own laws, it takes time. How am I going to be looking at creating a constitution or my own laws or all of that other stuff if I'm just so stuck in implementing what I have right now? And all of that is a result of, yes, the Indian Act, but two, the unfair First Nations federal fiscal relationship.
I'm sure there hasn't been an offer of support from the federal government towards projects like promoting the work that folks like you do. But has there been any resistance? Is there sort of an interest there that the federal government has in maintaining the current system as it stands in 2025? Or is there some role that can be played here in order to sort of transition off? I think you see where I'm going, but I'm curious for your thoughts.
The biggest resistor is us. I talk about this thing that I call Indian Act paralysis. Fear is a big resistance that we have to overcome. Not just those that want to exercise their inherent right to self-government, but our community. And you look at this thing called rights. Where does the inherent rights fall on? The inherent rights lie with the people as a collective. The community as a collective hold those inherent rights. And that's been proven in the court system. And it's not top-down approach, it's bottom-up approach.
What does that mean on the ground? What is the government not doing right now that perhaps us as non-Indigenous Canadians also can be like, that's not right. Right away, this is not right. This is not what's required of us in this process. Can you help demystify that a little bit for us?
I think the biggest thing is oil and gas. Canada says it needs to find a new exporting partner to export their oil and gas to. So as a result, they've created these pieces of legislation to expedite the processes that would usually be time-consuming, because you would do some stakeholder engagement, rights holder engagement. And that looks differently depending on each project. But basically what they want to do is build pipelines across the country so they can export this oil and gas. But there's this duty to consult and accommodate. And this has been affirmed through the court system. But what they want to propose is, we're just going to do this now. And we don't need engagement. This is in the best interest of all of Canada. So we're going to forego that. We're going to forego it all because this is all about the best interest of all of Canadians. And I've been thinking about this long and hard, because we're going to have to be the defenders of this land again. I find that we're the last line of defense against all these pipelines that are coming. And I'm not going to say let's all go out there and protest or, do roadblocks. I'm not saying that, but I'm saying this is where we go to the court system and say the Crown has a duty to consult and accommodate us, and we have not received that. Therefore, our Section 35 right under the Canadian Constitution is not being respected and recognized. Or what we could do too is we really educate our First Nations partners so they understand the right of the duty, the consultation and accommodation, so they can be applying that pressure too. A lot of times our communities take a passenger side of all this consultation and accommodation. They look at saying, okay, the province and federal government have their own process and we'll just kind of be along with that process.
Honestly, Dr. Ducharme is someone who spends my life advocating for democracy. I am so moved by what you're sharing. I really can't tell you how often I have conversations where I look at I try and explain what democracy is, and I don't think I could explain it any better than you do. I think I've learned so much in this conversation, just the notion that I truly believe in my bones that people have the right to self-govern, and that right is inherent, as you say, and that the systems that we put into place to consult and make decisions and to sort of take all of the little perspectives and opinions and points of view and lived realities and with the people who are part of that community, however big or small it is. The process by which we do that is so important, and really your nation building.
I love that, and I really appreciate this praise you're given. And I think I would push back just a little bit, because I know we're friends now, and say it's not nation building, it's nation rebuilding. We're rebuilding these structures that were taken away from us. But they're still there. They're still there. They're there in our stories. They're there in our language. They're there with our elders.
Thanks for listening to Democracy Explained. Democracy doesn't just happen, it's something we build together every day. If you enjoyed this episode, share it with a friend, subscribe on your favorite podcast platform, and join us next time as we dive into elections and integrity. Until then, chat about these ideas with friends, listen to new perspectives, and remember, democracy only works when we all participate. See you then.